welcome everybody to our fifth session of the Audit and Finance Committee for the budget. And today's November the 6th. It's the day after Election Day, and I just want to say congratulations to all of those seated around the table. Okay.
We made it.
Yes, we did, and it's over. Okay, we're going to start this evening with taking the roll call. Okay, we're going to do the roll call. We're going to start over here with
This guy.
Joe Clay, 12.
Lynn LaCagas, 8th.
Dave Mayo, 20. Paul Bergdorf, 23.
Mark Grimm, 29th, Gittelen.
Not on the committee.
Mr.
Joe O'Brien, the 25th District, Loudonville, West Auburn.
And one Willingham III, and I would just like to take note of our other colleagues that are sitting at the table.
Matthew Peter, 5th District.
Merton Simpson, 2nd District.
Patty Lafgard, 26.
Thank you very much.
Yeah.
All right, then, so we do.
And,
Sorry, I didn't see you back there. All right, so we do have a quorum, and we are ready to begin. All right, we are going to start with. We're going to start with the alternate public defender's office. Woo-hoo! Sorry.
76.
You want me to get the book? You've seen it? You've seen it?
I got this.
Congratulations.
Thank you. Good evening.
Soon to be Judge Brooks.
I don't know why
I don't know if this is your last appearance, but it may be.
It is.
Okay, it is definitely.
It definitely is.
Okay, well, we just want to say congratulations to you, and we realize you're going to do a wonderful job.
Thank you. I appreciate that.
So, we want to start with the presentation?
I think it's pretty self-explanatory. My office, I've been here for almost 8 years. It has been a pleasure. I've done this many, many times. I think everybody who's been in the room with me before knows that I have done everything I can with a very little bit of money. We have recently had the luxury of being infused with a lot of money due to statewide implementation. For that, I'm very grateful, although I won't be around to utilize it. I think it's a great opportunity to finally do some really good things in indigent defense. And so I think it's...
Now, we're on page 78 for those that are in our budget books. So, Ms. Brooks, we're in our second year of the statewide implementation, I see here.
Correct.
And we see three positions.
Yes.
I just want to ask just one question. Can you tell me what the supervising administrator does?
So right now, we have 2 support people in my office. So actually, both of them spend most of their time in our main office, but one of them splits time in the family court office. So the supervising administrator is essentially just an administrative position, but they would oversee the 2 support staff. So they perform administrative functions as well, but in a supervisory capacity.
Now, do any of our other members have questions of Ms. Brooks?
You guys really want me out of here.
You really worked the room before you came.
I did.
Okay, so if no one has any questions, we're going to send you on your way to your new position.
Thank you, everybody. It's been a pleasure. Thank you.
Sure, you're already reaping the benefits of being a judge.
I like this. Have a good night.
Good night.
Thank you.
You're going to be across the way for 30 seconds.
Very nice, very nice.
I'll get it later.
All right, we're going to move on to number 2, and we're to Judge Herrick. How are you this evening, sir?
I'm great. How are you, Madam Chair?
Just wonderful, just wonderful. All right. So, why don't you give us a brief overview of the office and some of the changes, possibly that have been made, or you think that we might have questions about tonight on the restructure of the office especially?
Well, this is I just finished my 3rd year as public defender.
Page 178?
I'm sorry? Yes. And
174.
We currently have 32 staff attorneys. 16 have been hired since I began in October of 2016. The majority of those new hires are entry level. Last year, we were able to increase the starting salary of a new attorney. And we now have and that was paid for by the statewide expansion of Hurrell Herring that was just referred to by Judge Brooks. We are now trying to implement a salary schedule that will not just create a first job for people, but a career. And so the request to Office of Indigent Legal Services was for 6 new attorney positions, which are 100% paid for by Hurrell Herring Grant, which is a 5-year distribution. We're in year 2. Those are at levels 2, 3, and 4 on the salary schedule. And so we hope to move people up. There are no additional increases on the salary lines other than the cost of living allowance that's provided for in the budget, proposed budget. There's just new 6 attorney positions, and there are also several new support staff positions also paid for by the statewide expansion grant monies. And there is a substantial amount of money for the materials, training, continuing legal education, and outside services that are, we believe, required in order to allow our attorneys to and staff to benefit and to provide excellent legal representation to the criminal indigent defendants that we represent. The statewide expansion monies do not extend to family court attorneys at this time, just the criminal defense attorneys, which are of the 32 attorneys, 28 are criminal and 4 are family court. And I'd be glad to answer any questions that any of you might have regarding this. But this is really any increases in the budget are paid for 100% by the statewide, or almost every increase is paid for by the statewide expansion. And we're also moving this year. We're relocating because our current space is not sufficient to maintain the staff levels and the support that the state believes we are in need of. So we'll be moving sometime mid-2020.
Okay. Are there any questions from any of the? Yes, Mr. Mayo.
The $26 million, is that just divided in 5 years equally, or?
You want to go? It's a budget question.
Okay, well, then maybe somebody else should answer it.
Wow.
Go ahead.
So it's a scaling progressive amount where it goes from, I believe the first year was 1.7 million and roughly 1.7 additional million every year up until the 5th year where you max out about 8.5 million.
And then what are the plans for that money?
Well, we would hope that they would continue, the state, to give that influx of cash for the rest of the going forward. Because with the...
And I can answer that. This is different from just a grant. This is based on a court settlement. 5 counties in New York State sued the state, and it was a settlement that the New York State Attorney General entered into, and this is an expansion of that settlement. The settlement in Hurrell Herring stated as is U.S. law, U.S. Supreme Court law, that it is the state's, not the county's, responsibility to pay for the cost of indigent legal representation in criminal cases. So this was not appealed, and it is now the case law in New York State. So my belief is if the state, absent some huge emergency, failed to continue the funding for the expansion of criminal representation for indigent defendants in New York State, that it would be a matter that would be settled by, I would say, declaratory judgment in court. It is New York State law that this would continue. It's not a grant that can be terminated or modified other than to continue at least status quo.
Excuse me, I'm sorry. Yes.
Thank you, Madam Chair. The bail reform, we're familiar with that.
Well, I'm not going to be familiar enough with that until a lot of things happen, and which is probably going to be very close to January 1.
What's your opinion on the effect on the town judges and the city court judges? Is their burden lessened by this?
It's going to be different. A lot more appearance tickets will be issued. However, in cases where so-called domestic violence cases, where there's a requirement of an order of protection to be issued, the judges are still going to be required to come out and do an appearance, if not an arraignment, in the middle of the night. And in Colony, for example, we had a meeting with the court staff, the judges and town attorney, and the police. Colony Police indicated they have somewhere between 1,200 and 1,500 DV cases every year, and many of those would require that an order of protection be issued. Now, we have the counsel at first appearance, so we provide legal representation, our office and in combination with the alternative public defender, for all appearances, for off-hour arraignments or appearances. And I use the word appearance because it might not be an arraignment. The DAs are generally not there, but the defense attorneys would appear. And that's part of Harrell hearing. It's also subsidized by separate grants, the counsel at first appearance. But I anticipate that there will be a different burden, but I'm not sure it will be less, it'll be different. Centralized arraignments are probably not in the near future in Albany County, and the audio-visual arraignments presently require defendant written approval or consent, which is unlikely to occur.
Okay, thank you.
Thank you, Mr. O'Brien. Are there any other questions? If you turn to page 180, in the fees for services, there is a substantial increase.
Okay. Fees for services is a substantial increase. I think it's $40,000 more than the current year. That increase has been requested and tentatively approved by Office of Indigent Legal Services. So first of all, it's state money, it's not county money. And it is in anticipation of the unknown, in addition to expansion of services for increased number of trials. Our office has become much more litigious than previously. Trials and experts and the traditional things, there'll be more of those. But I don't know, as I sit here, how the Public Defender's Office will be able to respond and fulfill our responsibilities for reciprocal discovery with the new discovery part of the Criminal Reform Act, which goes into effect in January. We may be required for this year to go outside of the county to get help to recover evidence that is being disclosed to us in accordance with the discovery statute, and we may require outside assistance to provide reciprocal discovery to the district attorney's office. It's an unknown, and as I sit here tonight, it is my understanding that the district attorney in Albany has not determined how they propose to distribute discovery information to my office, the Conflict Defender's Office, the Alternative Public Defender, or the assigned counsel, 18B attorneys. So until we know how they propose to distribute, we won't know how we will be able to recover it, what materials, technology, personnel might be necessary to do that, and then we need to reciprocate, which is a first. Up until now, Defense did not have to provide reciprocal discovery. Now we will, as of January 1, how we will get that back to the district attorney. So there's some unknown, and we have 50 days left. So that's in there with the understanding that we will have the ability to get whatever assistance we need to comply with the Criminal Reform Act. And that money is also, because it's state money, if it's needed somewhere else, it can be through, with county approval, can be allocated to some other necessary part of our office in the upcoming year.
So the 15-day rule
Yes.
also applies to the public defender's office? Is that?
No, no.
That's-
The 15-day rule is, first of all, let's put it in quotes, because there are going to be exceptions to the rule, such as if a grand jury transcript has to be prepared and the court stenographer is backlogged, they can get an additional 30 days, making the 15 45 days. But once they give a statement that they confirm that they have complied with their responsibilities for discovery, then we have to reciprocate. And that's, it isn't the same 15 days. It's after they have indicated that they have complied.
Okay. All right, so we just heard something about 45 days. Okay. Does anybody else have any other questions? No. Okay, so I noticed in here that you had a assistant public defender RTA, and that's...
That, they never funded that. That was for 16-year-olds, between 16 and 17. We have, since October 1, now been including 17-year-olds in Raise the Age. And I believe, and you can ask the county attorney in a few minutes, but or probation, I believe the numbers have increased somewhat since since October 1. So we're not yet aware of what the impact will be for the public defender's office or the county attorney's office or probation, but the indications are that there will be a greater need for representation in the youth court, in the adolescent offenders down in the family court building. And that will be something that the state has indicated they would reimburse the county for. They have done that with the county, or with the probation department for year 1, but they did not provide any monies to the county attorney or the public defender. So we were indicated for an attorney for Raise the Age, and I think a secretary, or part of the secretary. They didn't approve any funding.
So have you noticed an increase?
Yes.
Do you have any numbers for, in this first year?
I am sure that Mr. Connors has every number you will need.
Okay, all right, this is going to be interesting, because we have gone through a year, now we're moving into the second year.
Right.
And
now we're including 17-year-olds.
right, exactly.
And we've just gone through another summer in Albany, so with everything that brought us.
Okay. All right, are there any other questions from any other members? Thank you, Jim.
Thank you.
I would just like to invite our majority leader to the table if he likes, to acknowledge that he is here. All right, now we are going to the county attorney. Good evening, Mr.
Good
Lynch. How are
evening,
you?
Madam Chairwoman.
Do you have a page for that?
142. right, would you like to start with the presentation on your reorganization and so forth?
Absolutely, and I'll be brief. So this is the fourth budget that I've proposed to the Audit and Finance Committee. This is the first year that I'm asking the legislature to consider a reorganization for the Department of Law. This is in accordance with a move approximately 2+ years ago from our district attorney's office in the restructuring of a tiered system of attorneys within his office. It was followed up last year by our public defender's office in a similar approach. What I'm requesting here is basically a mirror to what exists in our county public defender's office. Assistant county attorney positions 1 through 5 with a pay based upon experience within the office and experience that was brought from the outside the office. So that's the biggest change in this proposal. There is the addition of 1 new position. That position is necessary for a variety of reasons. It's necessary because there's been an absolute increase in work product that has resulted from Raise the Age legislation. As Judge Herrick just mentioned, both his office and my office submitted a Albany County plan to New York State budget. I sought out 3 positions which appeared in last year's proposed budget: an attorney, an investigator, and support staff. All were denied. We have seen a tremendous amount of additional workload, as anticipated, directly on par with the projections that both OCFS and DCGS had projected going into last year. I'll add to the level of cases and why a new position would provide flexibility within my office. About a week and a half ago, I appeared in Albany County Family Court on a significant matter that was transferred out of Raise the Age Youth Park. This was an attempted murder charge, loaded firearms possession charge. These are the types of cases that I don't know if anyone had the foresight of what was going to be returned or transferred to family court, but it's happening. Having skilled attorney in that position in Albany County Family Court to handle these very severe cases is a priority in my eyes. So providing a new position would provide flexibility. It would provide the opportunity to hire someone who is capable on a regular basis or when needed to fill in on those significant cases that are now being returned or transferred into Albany County Family Court. I also want to address, and I presented a month or so ago in front of the Law Committee on a significant civil litigation matter that involved another department within the county. We were in executive session, so I'll keep the details to a minimum. But just for some context, the Department of Law handled a significant federal litigation case out of the Southern District of New York, wherein there were 28 named county defendants. And part of the process of the merger that went into effect in 2012 is to make a real attempt to keep civil litigation costs to a minimum. And we've strived to do that every year and have done, I think, a very good job in doing so. We handled that entire matter and came up with a fair and just result for the 28 named defendants, saving the county, I would say, and I indicated to the Law Committee, just millions of dollars, $2 to $3 million in attorney's costs up front. So that's significant, and it's one in which I need to provide more support to be able to handle those big cases. We had 2 full-time assistant county attorneys handle that from the commencement of that action. As you can imagine, handling such a big case with as many named individuals and the number of represented parties that we had, that it took up predominantly their entire days. So we were working in other parts in a skeleton crew to make sure that we're providing the best representation that we can to our other departments and so forth that happen to be parties of civil litigation. So again, the new position that's created is to provide flexibility within the office to tackle a number of, I think, very, very important issues and matters in which I believe the bringing in someone at a high level would provide that flexibility within my office. That's pretty much a quick synopsis of the requests, and certainly if there are any questions, I'll be happy to answer.
Do you have any questions? Mr. Mayor?
On the restructuring, is there going to be a panel set up, or who's going to make the determination on where everyone is in the hierarchy?
That's a good question, and I believe my deputy county attorney and I will sit down. There's close to a breakdown right now on pay scale. It's just, you know, there are levels within each range in which I believe, I think a lot of our attorneys, based upon their experience, could earn additional income or better salaries outside of the public sector, or outside of county government. However, with that being said, there are distinctions and exceptions within each of those brackets. So to answer your question, I think it's a discussion that will take place between Eugenia and I in making sure that we have the correct people in the correct tier.
And if someone complains vociferously,
I mean, it's people complain a lot about salaries.
Yeah.
It's not an uncommon complaint. I think that this provides an opportunity to more competitively place their salary in line, albeit with other executive staff legal departments. So right now there's inequity between our public defender and conflict defender and law. So keeping our terrific staff in place to not look, they don't have to look to the state. They have to just look internally within the county and say, well, if I jumped over to the public defender's office, maybe I make many more $1,000s a year. So this provides equity across the board. Do I think that it's going to solve all complaints about salary? No. I think there will always be, regardless of what the pay scale is, those that believe that, you know, they're underpaid.
okay, but they'll be able to make their case to you.
Yeah.
All right, thanks.
Mr. Pater?
Thank you, Madam Chair. Mr. Lynch, thanks for the presentation and seeing what we go through, having seen what we've gone through with the city with turnover on legal staff and things like that because of salary. I couldn't agree more that we need to make sure that they're making equitable, especially within the county. Turnover is more expensive than a lot of this when it comes to actually covering the workload, making sure it's done. With that said, your office handles like sort of pre-foreclosure and foreclosures and things like that. One of the things I sort of just want to ask you is one of the great expenses, and we found this in the city when it was going after people with code violations, that going after LLCs and other things are exceptionally time-consuming and take up a ton of time when you're trying to actually issue foreclosures and things like that, and you know, discover where to go with it. Do you have the budget and the staff necessary to sort of cut down on the time it's taking to process foreclosures, get them in the county hands, and then get them sort of stabilized and then over, I know you're not doing the stabilization, but then the county doing the stabilization so that it's then getting to the land bank or dispersed in a quick amount of time?
So we work hand in hand with our finance department, and I can assure you that as soon as there's a delivery from finance, it is immediately processed by our staff. We have a full-time attorney, a full-time paralegal that predominantly handle the foreclosure process. Both of them are so incredibly experienced in this area. I mean, we are absolutely fortunate and as a county to have someone with our real property attorneys experience, because it's unparalleled and unmatched across the state. So he's guiding that ship. In having conversations with him, he feels that he has a great relationship with finance, and as soon as there is a delivery to our office, it is promptly dealt with. Again, coming back to our earlier comment that I made, the additional staff member provides an incredible amount of flexibility to reassign current duties within the office to assist real property if there is a lapse. So just one position can really head off some issues that need to be dealt with moving forward, not just real property, but also issues that I now see are apparently going to be the norm with raise the age cases, but also with our vast civil litigation defense.
Thank you, Mr. Lynch.
Sure. Thank you.
I have a question. Can you just very briefly break down the type of cases between family court and real property? That you have different type of cases at the county attorney. Can you just give me a breakdown of what those numbers look like? And how many cases do you handle? And I know you can't give me, but what's the majority of your cases? And
So they're separate and apart. I'm gonna play like Judge Herrick here and defer to Mr. Connors, but let me tell you this, raise the age cases, and he's unfortunate to have to go last, but raise the age cases, here are the projections that the state gave us prior to, with full implementation, that after the 17-year-olds get introduced and complete the first year, which we are now in, there'll be 300 to 400 new arrests, which are going to total 100 to 150 new JD filings. A JD filing is a case that now no longer goes to the district attorney's office, but is handled, the prosecution is handled by the county attorney's office. Those numbers through the first year are right on par. And Bill will be able to give you, up until a couple weeks ago, a true number. But their projections that they predicted for the 16-year-olds met them. And we're going to see the same with the 17-year-olds, and there may be even more. So that's raise the age. These are cases that the JD cases in general have always been lower level misdemeanor offenses. You know, assaults, petty larcenies, criminal trespasses. Now that game has kind of changed because now we can receive transfers from youth part. And these are cases that, as the district attorney has explained to you, I believe, these are significant cases that go through the youth part with Judge Rivera, and if they're unable to make a showing of extraordinary circumstances, they then become ours. These can be, like I mentioned earlier, attempted murders, loaded guns, shootings, very significant cases that up until a year ago were handled in criminal court. So those are the types of cases that we're handling in family court. We also do, as you're well aware, we represent the Department of Criminal or Children, Youth, and Family Services on parental issues and family needs and those types of abuse and neglect type cases. We also handle those in family court, as well as PINs and support. So from the DSS end of things, we're also in court. So we have a full-fledged operation in family court. Real property, I'm going to have to get back to you, Madam Chairwoman, because we handle, I don't want to throw out a number that's inaccurate. I can tell you that that is probably the most busy or one of the most busy areas within the Department of Law. And we have such a luxury, and I can't credit him enough, of having someone with such vast experience to be able to process things more quickly than others possibly could.
Are you looking for numbers? Are you looking for number of cases that we do, or the types of cases?
sure.
We'll provide you that if that's okay.
Mr. O'Brien.
Is there more staff needed to process it quicker, or?
Well, there is by county law a requirement that you wait 2 to 3 years. 2 years for commercial, 3 years for residential.
That's county law?
Yes, before there can be the actual commencement of the foreclosure process. So we're not far off base with where we're at. And again, I think our finance department kind of drives this, and as soon as they're able to contact and provide us the necessary information to then begin foreclosure proceedings, we immediately do so. So that's, if there's a need currently, I think it's fully staffing the finance department, and they've had some difficulty, my understanding, in having people stay in positions within that department that has kind of slowed the process down, so to speak.
So the county law is 2 to 3 years, you said?
So for a commercial parcel, it's 2 years. For a residential, it's 3 years.
Do you recommend shortening that period?
I think that, I don't know the entire history, Mr. O'Brien, but I think that there was an attempt years past with the county legislature when they enacted the in-rem foreclosure policy to actually provide additional time. But obviously that can set up
The
a
housing
disastrous situation,
Yeah.
because if you can't pay early on, most likely you're going to be unable to pay as you go into year 4, 5, 6, or beyond. I don't know what the exact answer is, but
Well, the housing stock in Albany in general is quite old, so 2 or 3 years, that can devastate a building.
and I believe that the city has also a year enforcement after the warrant, so it actually provides an additional year of precluding enforcement.
Is there some way of your office making a recommendation to the legislature as to maybe shortening that? Would you be willing to entertain that?
We can
Work with us?
certainly opine on
Okay.
current status, and if there's any adjustments or modifications that would assist. But we can absolutely work on that for you.
Okay, thank you.
Okay, Mr. Peter, Rao.
Thank you, Madam Chair. Just one quick follow-up, and I don't know if it's state law or if it's county law, but one of the things that we've noticed in certain neighborhoods throughout the city is we'll have someone with a blighted property not pay their property taxes for years and years and years. They'll be through the foreclosure process, being given warnings, and then the neighborhood's back on the upswing. So they pay off the taxes to minimum, and they still sit on the property. And they sit in the property and sit in the property. So this recently happened on a parcel adjacent to my district where the land bank has half the parcel, and the individual rebought the back part of the parcel, making redevelopment impossible. So in what does the county attorney's office or legally do we have to stop bad sort of landlords from reclaiming property that they've already blighted and are not in the foreclosure process from repurchasing it from the right of first refusal from the county, so to speak?
Right, so Mr. Lynch, what we're going to do is, obviously, there's a lot of interest in this particular area. And right now, you have said you have enough attorneys as far as this, your property is concerned, your attorney that handles this. So, but the interest is such that I do believe this offers for another discussion outside of the budget.
Certainly. And Madam Chairwoman, if I could start, we'll address it in an opinion, and then I'm sure there'll be questions that will arise out of what the current status is of our handling, specifically with the Department of Law, and how we are, working with the Finance Department and where there can be potential modifications or adjustments. And then I will absolutely welcome the opportunity to follow up after that.
Great. Yes, Mr. Bergdorf, please.
Taking a look at your narrative and taking a look at the budget, it's kind of hard to meld the two of them together. Can you give us a sense of the big picture? When I first looked at this and I saw, oh wow, 21 titles added to the budget, but then below it, 23 titles eliminated from the budget. What it will be the net amount of your staff from front to back, and what's the change from last year, and recognizing that the base is a 2% increase, what is the net increase in total staff dollars? Just sort of a big picture.
I'll let you answer the staff dollars. Let me give you the breakdown of number. Last year in the 2019 proposed budget, there were 37 budget items for personnel. 3 of those were raise the age positions that appeared in the budget because we believed, after a number of conversations with our folks from different state representatives, that they were going to be funded and therefore reimbursed. That never happened. So those 3 positions were taken out this year, putting us at 34. And we operated over the last several years at 34 total staff. The proposed budget this year is 35. It's the that one additional new position that I've been discussing. As far as cost dollars, I'll ask Mr. Thalin to.
Well, I mean, as you can see from your net county share, roughly 2.1 million to 2.4 million, with the addition of the deputy at the 115,000 range, and then fringe associated with that, we'll say, is around 140, 150. There's not much outside of the 2% because your department is mostly non-union, right? Do you have any
Yes.
union? You have like three
unions.
Yeah. And I'm going off by memory here. So the other 32 positions at their salary, which probably adds up to around, I'd say, a little less than 2 million. So the majority of that, plus the salary of the one additional person, is roughly 250,000.
Thank you.
Mr. Quack?
Mr. Lynch, I noticed that you, for 2019, you did not have a deputy, and you are now asking to fund a deputy's position, or deputy's position, is that?
Correct. So, Ms. Condon, who sits to my left, has been the deputy county attorney, okay? But per the line in the budget, if you go back, it's actually under the title of first assistant county attorney. There needs to most likely be a discussion with our civil service to make sure that the proper titling is there. But since we had a first assistant, the position that we're asking for is a deputy county attorney to fulfill an opening that currently exists.
Good. All right, Mr. Grimm, did I see your hand up?
Oh, yeah, thank you, Madam Chair. Now, the first assistant county attorney, it says requested 107, proposed 112. What's the reason for that? Third line.
All of the adjustments for salary were, I believe, based off of the comparables in other county departments. So that position of first assistant county attorney was, I reviewed other county departments and provided a salary in which I thought was in line with others in that positions or within the respective or close to the same position within other county departments.
But won't that position become less significant if you have a deputy county attorney? Because then that becomes the third ranking position, not the second?
Yeah, well, the deputy county is 115 and the first assistant is 112, so there still be the salary hierarchy. I'm not following you.
I'm just saying you're giving a boost to that third position, even though the responsibilities would be less, given that you're going to have a deputy county attorney.
I don't look at them as responsibilities being less. I look at the filling of this position is vital to the operations and how we are moving forward. The position is going to tackle issues that are real big-ticket issues that need to be dealt with in the raise the age area, in our civil litigation area, and also providing the necessary flexibility to shift staffing to other needs that we have within the office, such as what's been identified earlier this evening with real property issues. So I don't look at it as a diminishment in responsibilities. I think in order to get a qualified individual in that position that can accomplish what we need to accomplish moving forward, it's in line with what that person should be.
Just follow up on what Mr. Bergdorf was asking. What is the overall increase in salary percentage-wise? I don't think you answered that question, as I recall. What would be do we know that?
We'll give you a specific write-up.
Okay.
I just eyeballed it when I went, Mr. Grimm.
Okay, all righty.
All right, if there are no other questions? Thank you, Mr.
All right,
Lynch.
thank you, everyone.
Okay, we're going to move to probation and Mr. Connors.
Good evening, everyone. So, any changes in the probation department?
Okay, 169 for all of the members, 169. Budget book. Thank you, Mr. Connors.
Good evening. So, many changes in the probation department going forward this year and into next year. And I know you might have many questions regarding raise the age and bail reform. So, I had start with bail reform. I recently appeared in front of the law committee last week to present to raise the age. Our contracts are finally ready with DCJS, and that should be in front of the full legislature next meeting. So, our Raise the Age grant is a culmination of over 2 years of work, multiple submissions to New York State. Our first submission was in late 2018, and we've had many multiple submissions since then. We thought our money would be available sooner, and it was placed in the 2018 budget, and the departments before me previously, they thought they were going to be awarded positions from the Raise the Age money, but they were not. Ultimately, probation department would receive the bulk of the money within the county. So the Albany County plan was just approved late 2019 by the New York State budget. It then moved to the DCJS Division of DCJS Division of Correctional Justice Services to administer our side. And it just recently became available for signature in our grant process, and I submitted it to the law committee, or through the resolution process for approval. So our Raise the Age obviously has increased juvenile delinquency as we see it. Originally, October 1st last year, it increased juvenile delinquency to 16, and October 1st, 2019 to 17. It also added a new court for us to assist in the process called Adolescent Offender Court, which is housed in Albany County Family Court, which the county attorney mentioned, Judge Rivera actually wears two hats on that court. He's acting Supreme Court Justice to run the Adolescent Court, and he's also a Family Court Judge at the same time. So if I could review the process quickly of how a juvenile moves through our system, it may paint a better picture. So a juvenile is arrested anywhere within the county, and if it's a low-level crime, they're given a preliminary intake. They appear at the probation department. We meet with the child and their family, and we attempt to adjust it, offering some type of services or programming when we feel it's indicated. The more serious crimes, the felonies, appear in AO court in front of Judge Rivera. We're also there at that time, and we offer the youth voluntary services. We meet with him prior to court and offer the juvenile voluntary services. So on these cases, Judge Rivera then arraigns the child, and on many occasions, and then again released to us to continue to provide services. So those cases remain with us while the district attorney has several days to consider, several weeks, I think 30 days, to determine if they're going to prosecute the case as an adult. So far, we've only had a couple cases prosecuted as adults. There are quite a few cases that remain in AO court, and quite a few cases that were transferred back to family court. So prior to Raise the Age, we served anywhere between 300 and 400 juvenile delinquent youth a year. This is children that were 15 or less. With the increase of raise the age and full implementation, we project up to 400 or more youth per year when fully implemented next year with 17-year-olds. So the first year, from October 1st, 2018 through October 1st, 2019, 150 16-year-olds were arrested in Albany County under the new law, raise the age, who previously would have been considered adults.
Do you have those numbers where we could actually get a report?
Yeah, I can provide a report at a later date. I just took some draft numbers.
All right, so we just repeat that number again, please?
So during the first year of Raise the Age, from October 1st, 2018 through October 1st, 2019, 150 16-year-olds were arrested in Albany County. Out of that, 40 were more serious adolescent offenders who were a felony or greater in class, and they went directly to the court to be arraigned in front of Judge Rivera. And then our department became involved with them, offering them voluntary services, or the court referring the matter back to the probation department to provide services. So about 150 16-year-old youth were arrested during that time. Since the implementation of age 17, October 1st this year, we've seen 31 total raise the age children, 19 16-year-olds, and 12 17-year-olds that have been arrested and seen at our probation department or been directly brought to court as an adolescent offender with Judge Rivera. So raise the age money is anticipated would provide for up to 2 juvenile units. So the first unit would provide supervision, intake, and monitoring, and the second unit would assist in all the programming of the children. We do a lot of programming within the probation department. We also contract with agencies out of our building to provide programming at night. So as the grant became available, the money is also sequentially available as the grant moves forward to full implementation. So even though we get our contract, all the money would not be totally available until the full implementation of the grant. So raise the age programming, we have a lot of programming in place. We're expanding some of our programming to accommodate the extra children. We're increasing our community service. We're increasing we have juvenile evening reporting centers. We have these at the LaSalle Institute and St. Anne's Institute. We're also increasing our capacity on the Juvenile Accountability Board, and we're also increasing some of our evidence-based programming within the department, an example, Career University. Some of the new programs that we're going to be offering for Raise the Age children is the Raise the Age we pay for electronic monitoring, another evidence-based programming, Girls Circle, Boys Council, another outside contract, MST, multi-systematic therapy. It's intense family services with children and their parents. We also plan to provide additional mentors in the community coaches, peer advocates, incentives to children. So our juvenile division has been very busy planning for Raise the Age children, trying to accommodate the increase in numbers, and we anticipate once the grant's fully implemented, we'll be able to begin looking at hiring the positions that were in the budget last year and this year in anticipation. Last year, where the grant was never approved on time, and this year going forward.
Okay.
Questions on Raise the Age?
Yes. Okay, are there any other questions? Yes, Mr.
Yes, thanks, Madam Chair. If someone is arrested, 16 or 17, for a violent crime, you say because you're talking about felonies, that means they don't go to jail?
No.
Then how is the public protected?
Good question. So Raise the Age, the whole concept behind Raise the Age was children not be incarcerated in adult jails. children that are arrested with raising age still can go to the juvenile detention center. They can go to the security detention center, and the JDs can go to the non-security detention center. So the court has opportunity to still put children in detention, just not jails.
All right, so a different kind of jail then, it's one
Right.
with other kids.
Yes,
But, you know, because whatever their age is, they could be dangerous, obviously.
yes.
So there is an opportunity to keep them off the street.
We have seen an increase in violence of some of our younger offenders, I'll be honest with you. We're seeing children that we've never seen in this capacity before, children that have weapons, guns, shooting other children. It is very concerning, and those cases, the court hears everyone and makes a proper decision whether they go to detention or should be released to the community.
Thank you. Thank you, Madam Chair.
Thank you. Mr. Clay?
Sure, under special programs, what is that?
What numbers are that?
172,
Okay.
250,000.
That's, my understanding is, so the county executive has a new initiative called Zero Youth Detention. And the probation department would be an important resource in the development of that committee. The committee has met several times. There's
You said zero use.
Zero Youth Detention. So the county executive has looked at several miles around the nation, and in Kings County, Seattle, Washington, they have a similar policy, and we've been looking at their programming model to try to implement changes in the systems within Albany County going forward. It's very new. It's the county executive. He's still forming the work group, as far as I know. And much more information on that will be developed in the county executive's
Yeah, but what's
office.
the purpose of it? I mean, what's the,
It would be eventually for no children to go to detention, zero youth detention. So we would provide alternate programming for children instead of being detained, such as programming either within the community or within our department or assigned to the probation department.
Mr. Bergdorf?
I'm having a little trouble following your previous discussion where you talked about seeing younger people with guns shooting each other.
Obviously, zero youth detention is a goal. There may be some situations that youth need to be detained. I think the county executive and everyone that's going to be a member of that group is aware of that, but the goal is for zero youth detention. Whether it can ever be accomplished or not, I wouldn't answer that. A lot of it is uncontrollable, is the actions of the child in the community, and when they appeared in front of the court that they were assigned to.
Follow up with that. Does the county executive via this task force have any ability to supersede state law on bail reform or judicial discretion? Or I'm not...
I would not believe so.
I'm not quite understanding how a program like this would work.
It may be more community-oriented to placing resources prior to the child being arrested in order to move them forward in the system.
What I guess what I'm hearing is that this is something new and that the county exec is exploring. Do you see that this is something that will be moving forward this year? Is this for?
Yes, we'll send you over specifics on this just to fill in the blanks that I'm sure there's some questions of, a high end on what this is. So we'll send over an outline of what this entails.
Okay, we'll accept that. Are there any other questions from any members?
Were we going to cover bail reform?
Yes, yes.
Okay.
So, bail reform is a next significant impact to the probation department going forward next year. So, bail reform would add 2 new functions to the probation department. So, let me preface that is that we're currently the pretrial agency in Albany County and designated an ATI agency, an alternatives to incarceration, under Executive Law 13A. Although we perform that service, we have not yet been named the agency that would provide the bail reform services, but it is all anticipated we would. So bail reform, all the changes would now reside with the Office of Court Administration, who would administer this, and we would report to OCA if we were to assume the bail reform. So the 2 parts that affect the probation department. The first part is every misdemeanor or low-level crime that is arrested, not all, up to 90% will be re-released. They will not be incarcerated or detained, except for certain cases of domestic assault, sex abuse, child abuse, more serious crimes that were not elevated to a felony but remained a misdemeanor. So 90% of the projected arrests in 2018, there were approximately 4,400 arrests for misdemeanors in Albany County. So going forward, 90% of those people will be released, 4,000 people, all right? And each one of those persons, the court offers the person the option of how they want to be reminded to go to court. They are text, email, regular mail, and telephone. And an agency that is going to be designated the agency to provide this service would have to have all the information on that person and remind them that they had to go to court and when their next court appearance was, so their preferred method of contact. That's a significant change going forward on how business was conducted in courts on misdemeanors, okay? So what we've done, looking at that, our current system that we have probationers on, the company has a pretrial product software that would provide this service, assuming all the information was loaded properly. It's by a company named Automon. It's called just pretrial, and within that software, an assigned staff that had these would be able to set it up where they would send either email, telephone, or text directly to the person by their preferred method of contact. Okay. The second part of bail reform impact on the agency that would provide that service, presuming if it would be the probation department, is the felony arrests. So in Albany County in 2018, there were approximately 2,500 felony arrests. And again, 90% of all these felony arrests are eligible for release. This release is at a higher level from the court. This is not where the individual indicates that by his preferred method of contact, although the court may still use that. In these situations, sometimes the court may order additional services to be provided, such as certain conditions to be monitored while the person is in the community, or even GPS monitoring of the individual. The court can authorize GPS for up to 60 days for individuals while their cases are pending. So it's difficult to project a plan without having numbers. So we have a current ATI unit that's funded by the state with a supervisor and several staff that already provide this function. We average between 250 and 300 offenders on pretrial supervision services in Orange County at any given time. That's where people have been arrested and been released to our department to maintain them before they go back to court. The assumption is many of the people arrested on bail reform would now replace those people. And our existing staff would assume a lot of that services monitoring going forward. We're going to do that. I'm also moving some staff around internally to accommodate additional persons within that unit for the services. We're going to be purchasing, we haven't decided yet. It went through the contract. I submitted a contract to be approved. I think it's with the county attorney. It was less than $10,000 for the software, so it didn't go to the full cab. To purchase the software, to train my staff how to use it, to enter all the names in, that would have to be reminded going forward. The unknowns are GPS units, how many the courts would require, and how many offenders at any given time. We have some money in our budget for GPS. I've just contacted our vendor to look at restructuring our contract to increase how many units we have, and if there's some way to open the contract for 2019 with bail reform. At sitting here at this table, I don't have any way to predict how much we would need in terms of additional revenue. So the county executive has placed revenue in reserve for the probation department. I think the district attorney also, if we were to do that, ask for money later on. I would have to wait, monitor the first quarter into the second quarter of next year to see what kind of services the court are asking for us. Looking at it, if they want to rely on GPS services, and we have put a lot of people on GPS services, that's going to bring our costs up naturally, and I would request additional funding for GPS later on. I'm realigning the unit right now that provides the services for ATI. If we get a lot of people that are released to our department that have to be maintained in any type of conditions, or we have to monitor them and refer them to programming, I may request additional personnel for that. But it's hard to project when the bail reform is actually incrementally as people get arrested and courts are releasing defendants to us to determine how incrementally the impact's going to be on us till later into next year.
Obviously, that, we just want to make this comment, there's a lot more to this bail reform.
There is much more to this.
That can actually be handled in this budget meeting. So I really would like to pull everything back together. We do probably, from what you're saying, we need to monitor this. But I think a separate meeting, so where we can ask questions on how this is coming along so far. I would like to, I don't want to go any further with this. I think we need to have a special meeting. I'll allow you one.
Yeah, I just, if I'm hearing you correctly, for bail reform, in many instances, you're going to set up automated systems, okay? Paul, this is Commissioner Connors. Remember, you got to be in court Tuesday at 2, okay?
That's the only thing that person gets under the low-level crimes, a reminder.
Okay.
And everything changes entirely for bail reform.
But my question is, what happens when I don't show up Wednesday at 2? Are you still in the equation? Are you the people responsible that have to go out?
No.
And where does that reside?
So, So if someone is arrested and goes to court, if they don't want to appear, when a bench warrant is issued, it goes back to the original arresting agency. So when people fail to appear in courts, it would be bench warrants that were issued. So there are courts that have multiple police departments that cover those courts. So whoever the original arresting agency was. But I have to caution you, the Bail Reform Act is very comprehensive, and when that person doesn't appear in court, there's not going to be a bench warrant. It's going to be up to 72 hours and up to 2 weeks longer, because the emphasis is that the person needs to be recontacted either through the original contact means or through his attorney or any other means to return to court. Just because they don't appear, there may not even be a bench warrant for quite a period of time. Everything as we know it is changing with bail reform.
Right. Again, I think this is cause for really a separate meeting. And I understand your questions because, Paul, I was thinking the same thing here. So, but are there any other questions pertaining to the budget? Ms. Lockhart.
Just wanted to ask you, if you did set up a separate meeting with the chair of the school committee, to let the legislators know, because I think a lot of us are very interested in
All right. I think that you said you would like to have this covered in public safety?
No, I'm just saying, if there is a meeting that's set up for the rest of the legislature to know, because I think there's a lot of legislators that are interested in understanding.
Yes, I think so too. That's what I'm hearing around the table. We know we can't cover this here tonight.
I'd be more than happy to come back anytime you need me.
Very good. Are there any other questions in regards to the budget for Mr. Thomas tonight? If not?
Thank you very much.
Thank you.
Thank you.
Thank you very much. Okay, can I get a motion for adjournment? Thank you, Mr. Cactus and Mr. Bud.